module 2, we're going to be looking at the basics of contracts. Right. So why do you need contracts in place? They help you manage relationships between the parties, right? They will spell out the rights and obligations of parties to the contract. And to a reasonable extent, they help you risk-proof your organization and the transaction you're engaging in. So some of the key contracts that you definitely need to have in place, I mean, ideally, any transaction you're having should be under a contract, but some key contracts that you definitely need in place are agreements with your co-founders, directors and investors, agreements with employees, consultants, and your vendors, non-compete agreements, non-solicitation agreements, non-disclosure agreements, IP agreements, right? And why this is key, I mean, let's look at one example. Let's say you're designing this product and you want a mentor's advice. This is somebody who's been, let's say it's a medtech device, and you want someone's advice who's been in the medtech industry for a while. And that obviously means that you're going to have to reveal information about your product and where you're at what stage you are at when you plan to fundraise. Now, all of these things are confidential things. Some of those are intellectual property related things that you will be revealing to this person, right? So ideally, what you want to do is have them sign a non-disclosure agreement so that they are under an obligation to keep this confidential as well. And that will sort of allow them to give you all the advice that they need to give you, and will protect your rights in the process. Now, what are the basic things that every contract will need, right? You'll have to spell out who the parties to the contract are. What's the contract's purpose? What is the consideration, right? Meaning, the service or the product that's being given is given for what? For what fees or payment? You're going to have to mention that. The contract formation date is something you're going to want to mention. The effective date, that is when the contract comes into effect. What is the jurisdiction of the enforcement of the contract? And risk mitigation and identification. So from this broad overview now, let's look at what are the key provisions in a contract, right? Now, broadly, as we said, correct legal names of the parties to the contract. You want to put the legal names in. For instance, if your company's name is XYZ Private Limited, you want to keep that entire legal registered name in the contract. You don't just want to abbreviate it and use your brand name or something else, right? Key definitions of critical terms you're using in the contract should be in the contract. So you should have a definition section. The scope of work and deliverables need to be listed. Your tentative timelines need to be in place. The terms of payment. So it's not enough to just say, okay, payment of 1 lakh. You want to mention the terms. What are the milestones of payment? For instance, is it 30% advance, and the remainder on, let's say, the completion of the work, right? And is this with GST included, excluded? Is this with TDS include, like deductions made at source or not? So these are things you want to cover in that. Then, of course, what are the rights and responsibilities of each party to the contract? You're going to want to have a confidentiality provision as well. IP protections, again, intellectual property right protections, remember they're critical, and this is how you can protect them through your contracts as well. Breach and damages, what happens if somebody breaches the contract? What kind of damages do you want for that? You don't want, from your point of view, you don't want unlimited damages, right? Always try to quantify the damages in place so that your liability is limited to the extent of your breach. And same for the other part. You don't want them to get away because the damages provision was vague. You want to quantify exactly to the extent possible how much they're going to have to compensate you if they breach their obligations. How do you want to terminate this contract, if at all? That needs to be covered as well. Then you've got your dispute resolution, jurisdiction, and governing laws. Let's say, I mean, no one starts out this way or goes into a business partnership thinking that things are going to go wrong, right? But we live in the real world, and occasionally things do go wrong. And when that happens, and when there's a dispute, what you don't want is to be with a contract where you just haven't figured how you're going to resolve the dispute, right? Whether it's through litigation, it's through arbitration, it's through mutual discussions, and then if that fails, then negotiation or arbitration. So you want to have that dispute resolution clause in. You want to decide which courts will have jurisdiction. Ideally, if you are the one who is hiring someone for a service, you're in that, where you're the client, you're in the position to keep that jurisdiction limited to where you are registered and where it's convenient for you, If you are the vendor, however, then you may have to defer to your client's jurisdiction. But either way, that place should be mentioned in the contract that, let's say, for instance, the courts of Bombay will have jurisdiction or the courts of Bangalore will have jurisdiction. And what are the governing laws, right? Those need to be in place as well. Now, in terms of some miscellaneous provisions, they're just called miscellaneous provisions, but they're not unimportant. They're actually quite important. You want to look at the entire agreement clause, that this is the entire agreement, and any past discussions you've had or any past documents are all either subsumed in this to that extent and part of this agreement or are no longer effective, depending on what your conversation is with your party, right? You want a severability clause that, let's say, one part of this contract is ineffective doesn't mean the whole contract is read down or inapplicable. You want a survivability clause. Now, what does a survivability clause do? Let's say you have a confidentiality obligation that you've imposed on the other party, right, for the duration of this agreement. And then you terminate the contract. You don't want that just because the contract is terminated, they can now go and rat out everything to everybody in the market. So you can actually continue this and say that this confidentiality obligation to the other clause that you want to have in your contract is a survivability clause. Now, what would you need this for, right? For instance, if you remember your confidentiality provision, what would ideally happen is for the duration of this contract, you're saying that this party is required to keep your information confidential. But you don't want to limit it to only the duration of the contract, right? Because at some point this contract might end, it may not continue indefinitely. And even after that, you want your confidential information to be protected. How do you do that? You can do that by putting in a survivability clause that says, the confidentiality clause or whatever number that is, let's say clause 7, will survive the termination of this contract indefinitely. So a survivability clause basically allows you to keep some things in place even after the contract has been terminated and protects you to that extent. Now, you also want to have an amendment clause. Let's say you want to change something in this contract. How can you bring about that amendment? Ideally in writing and by mutual agreement from both parties, right? So you want to put that in. Indemnification clause is also something you want to have in there. Indemnifying you against loss or liability, for instance, in cases as applicable. And then, of course, there's a vis major clause. Now, a vis major clause is important because very often there are things that are not within our control. Pandemics, natural disasters, accidents. And due to any of these things that are called acts of God or vis major, what can happen is the performance of your contract can be affected. But it would be unfair to kind of put the burden on either party in that case, right? So you want to keep a vis major clause that says in case of vis major events and then specify what those are, at least illustratively, that the provision, the obligation or, may temporarily cease or may resume once it's possible, and that there won't be a liability on the parties involved because that is unfair, right? This is something that's outside of their control. Nobody has committed a breach here. Nobody has knowingly acted in bad faith. So you don't want to impose liability on your client or your service provider in this case, or on yourself. So these are broadly the provisions that contracts need to have. Now, basis what kind of agreement it is, there will of course be provisions you may need to add to these, but these are a must-have. These definitely have to be in place. Okay. Now, in terms of best practices, right? Let's look at what are the things that we should be doing for contracts. Give your lawyer a clear picture of context, facts, and needs. Yeah. Comply with relevant legal regulations. So you can't have a contract that is basically whose objective is illegal, right? That's just not permissible. I mean, you can technically draft that contract, but it's not a contract that's enforceable in the eyes of law. So your contract should definitely reflect your proposal or scope of work sections to the extent that they're applicable. These should be included in the contract. It should be clearly titled either a contract or agreement along with its nature. So for instance, if it's a contract for services, that title should be contract for services or agreement for services. Remember to use clear, concise, and consistent language in your contracts. Pay attention to punctuation and grammar. One comma in the wrong place can change the meaning of an entire sentence. And in the case of a contract, actually have very real world consequences for you. Right? Read the contract, the appendices, the annexed and documents incorporated by reference before signing. So don't just read the contract. If it's referring to other documents, make sure you read those. If it has annexures, make sure you read those, right? Always consult a lawyer while reviewing contracts and before signing them. And ideally, it is advisable to notarize your contracts, but the ones that should definitely be notarized are your partnership, co-founder, and director agreements. At least those should be notarized. Yeah. And what you want to do is you want to develop templates for relevant agreement types with your lawyer. So create your own templates with a lawyer, right? Have the lawyer draw up things that you would need for your business and keep those templates in place, but make sure they're customized for you and your organization. What are some things to avoid? Please do not use random template agreements without tailoring to your situation, right? I mean, just a basic Google search will give you 50 templates, but just to pick that up and cut, copy, paste that is not a good idea. Those templates usually are a starting point, okay? In terms of, let's say, what are the key provisions you need to cover in a particular kind of agreement. But you always, always have to custom make things for yourself with the help of a lawyer, right? Do not rely on verbal agreements alone. Do not be ambiguous or vague, more so if you are drafting the contract, because here is a not so fun fact. If you are the one drafting the contract and you put in something that's vague, that vagueness is going to work in the favor of the party that did not draft the contract, right? Do not neglect future scenarios to the extent that it's possible. Make sure that you factored them in. For example, that vis major clause we just spoke about a while ago, that's an example of factoring in a future scenario. You don't know what can happen, but you're factoring in that there are certain risks. And so you're risk proofing your transaction in the contract itself to the extent that you reasonably can. Nobody can predict the future, so that's not expected of you or your client or service provider, right? Do not fail to update the contract if the terms are renegotiated. This is where your amendments would be helpful. The amendments we talked about as clauses. Yeah. Don't accept restrictive and one-sided clauses. Make sure that that contract is fair both for you and the other party. Do not allow terms and conditions that you don't understand or those that violate your company's policy. Yeah. Don't sign a contract that kind of flies in the face of your company's policy. Don't allow unlimited damages. Quantify your damages to the extent possible. Do not agree to obligations that you can't legally fulfill, right? You cannot do that. It's not permissible to have a contract, as we said, that goes against the law of the land. And do not sign contracts without vetting them personally and without your lawyer having looked at them and given you the green signal. These are things that you want to avoid. Yeah. All right. So that brings us to the end of module 2. And while we all want to proceed on trust, of course, and in business relationships and all relationships need trust to function, but you want to trust and verify. So do keep that trust, and not actually antithetical, but as part of that trust, do enter into a codified written agreement that protects you and the person that you trust to participate with you in this transaction or venture. You know, it provides you both coverage. So make sure that you do what's best for your organization and let the other party do what's best for theirs as well, through codifying things and making it clear rather than keeping it all vague and verbal.